Your Honour, today we have a hearing in the matter, a case management conference, I should say, in the matter of CFI 20 of 2015, Al Mojil and another, and Protiviti member firm Middle East Limited. Representation for the claimants and appellants is Every's Legal Consultancy. Lead counsel is David Head, QC, in London. For the defendants, Clyde & Co, LLP, lead counsel, James Brocklebank. I have a quick statement to make for the purposes of this video conference. For the record, the sitting of the DIFC courts is taking place in Dubai, although the record will reflect the fact that lead counsel for the claimant and lead counsel for the defendant is appearing in London by means of video conference. Any orders made in the course of or at the conclusion of this hearing will be made on behalf of Sir David, at the instruction of Sir David by the registry in Dubai. Will both Sir David and the parties please kindly confirm that they are aware of that procedure?
Yes.
Can you hear us all right? Good.
Yes, we can.
I hope that's clear and satisfactory. Thank you very much. Do sit down, please. Yes, Mr. Head.
Good morning, Your Honour. I ought also to mention, by way of representation, that I appear together with Mr. Jonathan McDonough, and Mr. Brocklebank appears together with Ms. Clara Ben.
Yes.
My Lord, Your Honour, before we begin, can I first thank you on behalf of all parties for permitting us to appear by way of video link from London. It's obviously they've saved both sides a significant amount of time, effort and money.
Yes. Well, it saves a bit of money too, yeah.
Yes, quite. By way of agenda, Your Honour, you will have seen in Bundle 1, Tab 21, that there is an agreed agenda. It's got 10 items on it.
Yes.
And you will have seen that most of those items are either pretty straightforward or indeed not in dispute. There is a separate item which is mentioned at the bottom of the agenda, which relates to our application to exclude from evidence certain material which has been adduced in witness statements served by the defendant. I'm sure Your Honour will have seen that matter addressed in the skeleton argument. That is a little more substantive, no doubt. As Your Honour will know, the defendants have taken issue with the timing of that application. They do have complaints as to the lateness of the application notice itself, certainly. I think, however, it is common ground that the court needs to address the substance of that application. We will be contending that this is a matter which is appropriate for the court to decide on now, and indeed for the court to exclude that evidence now, not least because if that evidence is not excluded, it leads to the need for us to get on with further significant work, for example, potentially further evidence, and with that, further work in relation to evidence and so forth. I know Mr. Brocklebank will be saying, well, look, the court doesn't need to exclude that evidence at all, and insofar as it's not helpful or relevant, then the court can deal with it at trial. But I think in joining in that debate, I think the court is going to have to look at, albeit hopefully in relatively brief terms, have to look at the content of the application. With that said, Your Honour, then I'm entirely in your hands as to the order in which the agenda items are dealt with. Certainly, so far as our skeleton is concerned, we've dealt with the application to include evidence first, and I'd be happy, and perhaps my preference would be to deal with it first before moving on to the more straightforward items, but I'm entirely in your hands.
Well, I think there are one or two items we might just try and dispose of. One which is not actually mentioned in your agenda, and not a complaint, but it's really a matter that has occurred to me, having got into some of the documentation. I suppose it constitutes a bit of a judicial whinge about the pleadings, which are pretty prolix. Can I just understand? First of all, there is a re-amended particulars of claim and an amended defence, correct?
That's right.
Right. And so the defence has not been re-amended in the face of the re-amended particulars of claim. Maybe the dates don't work, because unfortunately the defence isn't dated, I don't think.
I'll be corrected if I'm wrong, Your Honour.
Oh, it is dated, I'm sorry.
Yes, and my understanding is that the amended defence, albeit only amended, not re-amended, is responsive to the re-amended particulars of claim.
Right, thank you. Now, what about the reply, which again is not an insubstantial document? I ran out of enthusiasm reading it, but is this a reply to the amended defence, or what?
Again, I'll be corrected if I'm wrong. The reply was drafted in response to the original defence. It has not yet been amended in relation to the amended defence. I will say, Your Honour, that in part that is because the reply raised a number of matters that now appear in the re-amended particulars of claim. So I understand that there was...
Well, I can't say that's a joy to look forward to something repeated in both the particulars of claim and the reply, but there it is. If the reply needs to be revised, it should be.
I take that point.
Right.
Yes.
Now, the next point on the pleadings, I have to say I would be grateful if a version of the re-amended particulars of claim, devoid of the colour and devoid of the alterations, could be produced. It's an unworkable document at the moment, if I may. I mean, we'll need it, of course, but I need a document which is a sort of straightforward run in black.
That will be provided.
Thank you. The third point on this is these pleadings are, by any standard, long, and certainly so long as they require a summary under the rules. And I would like to see, and I think I'm right about that. I'm sure I've got the rules in front of me. Maybe the rules are the same in England, I don't know, I can't remember, but where a pleading is more than 25 pages long, at least in this jurisdiction, there should be a summary. So I will ask for a summary of all three items, please.
Of course, I'm told in fact, Your Honour, that summaries do exist. For reasons we can't...
Oh, I see.
They don't.
There's not much point in having them if they're not there. Right. Well, perhaps somebody can dig around in the basement and see if they can find them. Thank you. Right, well, I think that's all I want to say about pleadings, unless somebody else has got something else to say. The only other topics, some of the more two mundane topics. Firstly, video link. It's agreed that the second claimant should give evidence by video link. I'm entirely content with that. As I understand it, he is in Geneva, is that right? Or will be?
Yes.
What's the time difference?
The time difference between Geneva and Dubai is 3 hours.
3 hours. Well, even in May, or is that what it is now? It changes, doesn't it? I can't remember. Anyway, there is a time difference. So the court would have to sit later than it would normally do, correct?
Well,
So we would have to
again, we're in the court's hands. Of course, my client will make himself available at any time to suit the court.
Well, if I sat on our normal hour, he'd be giving evidence at 7 o'clock in the morning. Seems a little harsh, but okay. Well, it's a point that needs to be thought about.
Yes.
And it is very important that the quality of the video link is of the highest level. Again, not a complaint. The quality of this particular video connection we're operating with isn't frightfully impressive. So we need to do better. Again, that is not something to be left to the last minute. Somebody, oh Lord, we haven't done the video link. Let's run around Geneva and see if we can find something. You need to find something now, or at least within the next month or so.
Understood, Your Honour.
Now, trial bundles. I have no fervent feelings about this. And so far as size is concerned, I'm getting so old and blind that A5 is a bit small sometimes. So I prefer A4. I'd also prefer single-sided. A core bundle is going to be crucial. And that must not contain any substantial documents like, I don't know, contracts or matters of that kind. And it must be paginated, of course, the same as the trial bundle. Now, as I understand it, I'm being asked whether I want the rest of the bundles in hard copy or in electronic form. Is that the question?
I think it is, Your Honour. I think all parties, or certainly all advocates, have indicated their preference for hard copy bundles. But if the court would prefer electronic bundles or hard copy or bundle and electronic other bundles, then so be it.
Well, I think that from the point of view of the proceedings, a electronic bundle won't work unless we have what I call specially organised features for the exhibition of the documents, which usually requires a sort of opus system. But if the documents are in electronic form, I would like a stick or CD with them on. Okay. Sorry, now, just looking back at my notes, there was one other point I should have made about the pleadings. You're not the author of the particulars of claim, I don't think. I have to say that they are quite long on submission and evidence. When you have another look at it, I'd be grateful if you consider whether it's in a form that's appropriate or indeed legitimate under the rules. There it is. It's just a slight warning bell about it. Submissions in a pleading are very irritating. Right, now, next, timetable. I must tell you that although you happily say that this case could be completed in 4 weeks, this case has been set down for 3. I can probably... What happened, as I understand it, was that in the case management conference, what was said was that it was 3 to 4 weeks, which is not a particularly helpful estimate. Anyway, I put 3 weeks in my diary, the court has put 3 weeks. I can probably do more, but I must tell you that we should be trying to aim at 3 or 3 and a bit. Now, one particular aspects in which there would be a degree of latitude, and we're not going to debate the point now, we might have to come back to it in April, is the extent to which both opening and closing submissions should absorb the timetable. I'm presently advised, I'm quite content to have skeletons running to 75 pages, almost brief compared with some that seem to come along. But I don't think we really need each side to have a day or so opening their case. I think half a day each, or perhaps 3 hours for the claimant and a couple of hours for the defendant. But let's come back to that. But we should be moving on to the evidence on day 2. So far as closing submissions are concerned, in this court there is a practice which I think is actually reflected in the rules, that the parties are entitled to furnish written submissions. And from the court's point of view, are entitled to have oral closing submissions. But from the court's point of view, oral closing submissions are better entertained when the court has had an opportunity to see the written closing submissions, so they can actually ask some sensible questions. And for the moment, again, we need to come back to this perhaps in April, but as presently advised, I would have thought that the right thing was to hive off the closing of the case, both in terms of oral submissions, because we're not going to, I think, have much opportunity to grant you a day or two to write written submissions, to have a written submissions at some date after the hearing, followed by, if required, an oral hearing some time after that. Now, I appreciate that may impact on other people's engagements, but from the point of view of the court, I think that is the way forward. But as I say, we're not going to get bogged down in these time points unless you want to. Today, we'll come back to them. We'll have to perhaps impose some limits on the scope of, or not so much the scope, on the timing of cross-examination of factual witnesses and expert witnesses, but I'm not sure I can contribute to that debate on what I've read so far, so I don't think we can deal with that today, but I will entertain any points you want to make. Now, those are the only topics that seem to me to be pertinent before we get on to MMG.
Well, thank you, Ron, for those indications. They're certainly helpful, I know, to both parties. Let me say this, perhaps briefly, in relation to timetabling. Certainly from our perspective, we don't think it's appropriate to engage in detailed timetabling for trial at this stage, not least because, of course, we don't yet have the expert evidence of any discipline, and so the need for cross-examination and the extent of that cross-examination will become much clearer in due course. So far as the overall timetable is concerned, we, as Your Honour knows, we have provided some provisional indications of the time we think we may well need for cross-examination of both factual and expert witnesses. Now, and of course for opening submissions. But for myself, I'm entirely comfortable with the idea that any opening submissions from this side should be no more than half a day. So far as cross-examination of factual witnesses is concerned, we've been reasonably generous in our provisional estimates because we have been served with I think 7 witness statements, many of which are very substantial indeed, and therefore there will be some need to go into that evidence in some detail. As far as expert evidence is concerned, I know the defendant says, well, a day for each expert should be sufficient. That may be so, although, as Your Honour will have seen, the expert evidence does play a prominent role in this case. So I think overall, we think that a 4-week estimate is probably realistic. From where things look at the moment, I find it quite difficult to see that it is realistic to finish the case in 3 weeks, Your Honour. But again, I'm happy to return to that topic. So far as closing submissions are concerned, it doesn't surprise me at all that the court would wish to have written closings before all. We will have to, I know, be sensitive, I think, to direct commitments on both sides of the court, so far as listing any oral hearing, if there is going to be a significant gap between the close of evidence and those closing oral submissions. But again, that's something we can return to.
Just looking at the case management order, I see no provision for meetings between experts. Was that a topic that was raised?
It was a topic that was raised. It's not something that, as far as I'm aware, either side has progressed. The expert evidence now will, in some cases, not be served until mid-March or thereabouts. Now, whether the remaining timetable provides sufficient slack to thereafter have meetings and joint memoranda, that sort of thing, I think is open to doubt. It's not.
Well, I would have thought meetings are much. I think meetings are much more useful than getting supplemental reports. What is usually more effective is a meeting followed by a supplementary report in the light of the meeting. My experience, particularly perhaps in relation to expert evidence of law, is that once meetings start to take place, all the issues either evaporate or largely evaporate. And I'm, of course, sitting in this court pretty used to seeing evidence in relation to UAE law, or Kuwaiti law, Saudi law, and so on. And my experience has been that the level of agreement achieved between the experts is at a very substantial extent. And I think you need to think about this. The trouble about supplemental reports is that they simply embark upon the witness seeking to support his original views perfectly legitimately, but it doesn't really involve any standing back from the issues and seeking to see where the true issue, the true debate lies. And I would much rather have meetings than supplemental reports. But give me your thoughts about that before we break, I think. And again, I'm not sure it will work with regard to forensic accounting. That's perhaps in a slightly different category. But again, my experience is that if the two experts give their evidence together, the level of agreement becomes even more startling. So we shall see. I may well insist that the experts give evidence at the same time. That may work with the forensic accounting, I don't know, it's not a field which I'm so familiar. Right, but I do want your help before we break on the question of whether we have set up a timetable for meeting following the exchange of experts' reports.
Very well, Your Honour, and it's probably sensible if we have an opportunity to discuss it between the lawyers at this end, and no doubt.
Yeah, well, we might take a break at some stage and you can talk, Mr. Brockback, and then we can resume and see where you're getting to.
Yes, we'd be grateful for that.
Okay. Well, I think that I don't think there's any other topic on which I have anything to say. And so we're on to MMM, or MMG. Yeah. Well, now I've read your discussions, of course. I have read I think, reasonably thoroughly the section of Bundle 2 in dividers 38 to 41 or 38 to 40. So I think I'm reasonably up to speed on it. My initial reaction, if it's of any interest, is that I feel uneasy in terms of the degree to which I have a grasp of the issues in the case, in taking a position that certain evidence should be excluded at this date. It seems to me that the potential for prejudice, if material is admitted which in due course is thought not to be relevant, is pretty limited. It seems to me to be a topic on which I should keep under advisement, and if in due course matters rather come to a head as to whether a particular topic should be aired or whether it's relevant or whether time and money has been wasted on it, we can deal with it then. But there are quite a range of at least possible areas in which the MMG story could play a part, probably a very small part. I suppose also it may raise its head in relation to questions that go simply to credit. I don't know. But as presently advised, I would be reluctant to take it or leave it stand on this material. I'd like to be much better informed about the case, and I suspect I will be in a much better position to take a view on whether all or part of this material should be excluded once the case has been opened.
Well, Your Honour, thank you for the indication. It's certainly helpful to understand the court's initial reaction. And of course, we're realistic to understand that in many ways, the easiest thing for the court to do is to await trial, and we acknowledge that at trial the court will know more about the case. And indeed, as Your Honour will have seen, we've cited at least one English authority in our skeleton argument with Justice Mann, which indicates that at an interlocutory stage the court ought to be cautious and only to exclude evidence if it's clear to the court that it won't become relevant, or if it is relevant, that it's not of sufficient assistance to warrant that evidence being adduced. So I do acknowledge before Your Honour's indications, the uphill task that I face, but nonetheless, Your Honour, I do beg some indulgence, because we do say that on the fact of this particular case and the allegations and the issues between the parties, this is a pretty clear case where this evidence is of no assistance to the court and has the capacity to cause real prejudice to us, not least because that the evidence that's served, if permitted, will require an evidential response from our client. As I indicated earlier, that potentially entails seeking further documentation, serving supplementary witness evidence, possibly even the input of expert evidence. Now, in a case where, as all parties acknowledge, there is a tight timetable, both leading up to the trial and at the trial itself, we suggest that is to be avoided, and that the just and proportionate way forward is for the court to exclude this evidence. What I do want to just show the court, because I suspect the court would have not conducted this exercise yet, it is the underlying documents which show that this MML issue, if I can abbreviate in that way, was previously the subject of substantial debate and issue within the pleading, and then was explicitly removed from both sides' pleadings on the basis that it was wholly irrelevant. And just to make that point good, Your Honour, can I ask you to go to the supplemental bundle, or it might be entitled Bundle 3.
Yeah.
And tab 1 of that bundle is the report itself. This is the report that's at the heart of the case about which complaint is made. And Your Honour will see that at page 11 of that bundle, and it's internal page 11 of the report itself, there are a series of key findings. So following the defendant's investigation of MMG, they had a lengthy report, but it was effectively an executive summary at the start. A number of key findings were made, many of which made it through to the charge sheet, which was eventually put forward against my clients and others. And you'll see, for example, at page 11 itself, paragraph 2 refers to inaccurate percentage completion leading to inflated revenues. That became what's been termed violation 4 in the charge sheet and in the pleadings subsequently. So it suggested that revenues were inflated because projects were assessed as being more advanced than in fact were. If one goes forward to page 13 and paragraph 8, one sees that there's a reference to a cash contribution by owner amounting to 271 million reals, not supported by documents, and that became what's known as violation 1. Over the page 14, paragraphs 9, 10, 11, and 12, it effectively became violation 2, so in essence the overstatement of fixed assets within the company's accounts by reference to various different categories of assets, vessels, land, buildings, machinery, equipment, vehicles, etc. Those were matters which were ultimately the subject of adverse findings by the CRFD against my clients and others. You'll see at page 15, Your Honour, under paragraph 13, key finding 13, that there is this reference to MMM. In short, between September 2008 and August 2011, 13 payments totaling $63 million made by MML and documented, and various criticisms about the documentation and evidence seen, which said mean that those payments were not justified by reference to the contract that they purported to relate to. So that was the finding made in relation to MML in the report itself. And just while Your Honour's in that bundle, we see at page 198 of the same bundle, this is the charge sheet that was prepared by the Capital Market Authority. To page 198, you see the 6th violation, finding a deceptive and misleading impression about the value of the securities of the company, urged third parties to sell and buy on this paper, including abnormal financial payments. And then we see over the page again, September 2008, August 2011, 13 million. So it's important to note, of course, that those alleged payments related to a period following the IPO of MMG, which took place in May 2008. But in any event, the MML matter formed part of the charge sheet that was advanced by the CMA. Now, putting the supplemental bundle to one side, I think. If one then goes then bundle 1. And tab 7. This is the re-amended particulars of claim. But although we will certainly follow Your Honour's indication and remove the amendments. In fact, the marked up amendment version are useful for understanding. And just to explain to timing, original particulars of claim were served on the 28th of June 2000. Same day.
So you're rather cutting in and out. I'm sorry, I'm not quite catching what you were saying. Could you say that again?
Yes, I'm sorry. The original particulars of claim served by the claimants was dated the 28th of June 2015. Yeah. So, and importantly for present purposes, it was before the claimants had sight of the full report. You may have seen that it was only in 2017, February 2017, when this court made an order compelling disclosure of the entire report, that my clients had sight of the full report, including the supposed evidence upon which the conclusions expressed in the report were based. So the particulars were served before the sight of the full report, and importantly, before the CRSD had issued its ruling in relation to the charges brought. That ruling was not issued until the 16th of June 2016. So, in other words, at the time the particulars were served, violation 6, as it became known in the charge sheet, relating to MML, was very much a live issue. And one can see that if one goes to page 107.
Yeah.
You can see that although now deleted, the particulars raised the wholly secret violation 6, referring in detail to the executive summary of the report, referring to substantial irregular payments.
So can I just understand the colours here? The paragraphs 88 and following were originally in black, were they?
Yes, that's my understanding. Yes, my lord.
It seems to look as if they're in blue, but never mind. Okay, right, I understand. Thank you. They're crossed out in blue. Yeah.
Yes, they're crossed out in blue, but these form part of the original particulars.
Yeah.
So it refers to the various statements made in the report about the MML transaction.
Right.
The fact that it's substantial irregular payment, the fact that paragraph 89 has the hallmarks of a corrupt payment. Had MMG not secured this contract, likely the financial losses would have been materialised much earlier. And the allegation made by the claimants was these statements are completely false and without foundation in fact. And one sees at 91 through to 93 and through to 97.
Yeah.
The claimants engaged with the substance of what had been set out in the report in relation to that issue. It refers at 91 to the contents of the report, at 92 to the charge sheet following that, and at 93 it points out that the report failed to address with adequate basis that the company was diligently investigating the matter. It resulted in the company filing a claim against MML that was won by the company before the Dubai Court of First Instance. The company previously took a provision for these costs during settlement of the main project. 94, the company was awarded a court judgment issued on the 25th of August 2014, held that the contract was terminated, required MML to pay the company $63 million. 95, the report concludes in the potential offences section that the MML transaction is potentially money laundering. Claimant's position is unequivocal, no money laundering has taken place. 96, the defendants negligently failed to show the full picture within the report, picked only a sensationalist fragments, could be seen as damaging to the company and the claimants. At a loss to understand why the level of detail was not provided. So, and then goes on to frame those complaints as a matter of the applicable law, namely Saudi law. So that was the subject of the original particulars of the claim. We see that the defence as originally served, again, over tab 8, Your Honour has the amended defence, but again, one can see the unamended, or the parts not marked up, formed the original defence in the same way as with the particulars just seen. Importantly, the original defence was served much later, so the 19th of December 2016. So nearly 18 months later. The reason for that is because the defendant unsuccessfully disputed jurisdiction in this case, which led to a significant delay, and there was then an appeal at which the defendant was similarly unsuccessful. So by the time that the defence was served, the CRSD had issued its decision, and in short, the violations that were upheld by the CRSD were violations 1, 2, and 4. And we've set out the nature of those in our skeleton, and I pointed to the parts of the key findings in the report itself that those violations flowed from. Now, if one goes forward to page 149 of tab 8, one sees that.
Sorry, say the page again.
Sorry, Your Honour, page 149.
Yeah.
Paragraph 67 of the original defence.
Yeah.
We see that, again, by this time, the defendant positively pleads the state of play following the CRSD judgment. It says the CRSD judgment found the claimants guilty in respect of violations 1, 2, and 4. It did not proceed with alleged violations 3, 5, and 6 in the circumstances, and it takes the point in 67.1 that we're not entitled to contend that the claimants were not guilty of the matters found against it by the CRSD. But it's 67.2 that's important for present purposes. It says, if and to the extent that the claimants rely on any element of the report not related to violations 1, 2, and 4, it is denied that any such element can have caused any loss to the claimant and/or is relevant to the claim advanced against the defendant. So there is a positive pleading by the defendant that any matter in the report not related to violations 1, 2, and 4 is not relevant to the claim advanced. Notwithstanding that broad contention, and without prejudice to it, the claimant then did deal with the substance of violation 6, and one sees that at page 171.
Yeah.
Once again, Your Honour sees that now it has been struck through, but one can see that that the matters that the defendant engages in some detail over the course of 5 or 6 pages with the matters that were raised in the particulars of the claim relevant to violation 6, so in other words, the MML issue. So, pausing there, Your Honour, the point that we would make at this stage of the matter is that it is very clear that there was a detailed and complex story on both sides, no doubt, to be told about the MML matter. but the defendant had positively pleaded not relevant to the claim because it was nothing to do with 1, 2 and 4. Now, my clients then served a reply in February 2017. That is at tab 5 of the bundle. And as noted, that this is the original reply that remains in a form that it was served in February 2017. And at page 36 of that tab, the court will see paragraph 48 of the reply, which responds to paragraph 67 of the defence, the paragraph court. Paragraph 67.1 is denied. As to paragraph 67.2, following disclosure of the report pursuant to the court order dated 5th of February 17, and following the delivery of the appeal decision, the claimants rely only on those parts of the report related to violation of 1 law. So in other words, at that stage there is consensus between the parties that the only relevant matters are those matters related to 1 to what then happened in order to get to the pleadings in their current state is that the re-amended particulars were served on the 9th of May 2017. As you've already seen, I won't take you back to it, but all of the pleading relating to violation 6, so relating to MML, was deleted. And then the defendant served its amended defence on the 15th of June 2017, and again, the defendant deleted all of the matters that it had pleaded in relation to violation 6. What we get to is that it is common ground on the plea that this part of the report is irrelevant to the claims that are being advanced by the claimants. And on that basis, there was nothing in the claimant's own factual evidence in ML. And of course, the expert evidence has not been served as yet, but there's certainly no intention as presently stands to do that those deal with anything relating to MML. But then, of course, what has happened recently when factual evidence has been served by that there were significant for the MML. Now, the point that we would make about the evidence that's been served is the point is made against us. Well, look, in total, these the extracts that are complained about in the amount, I think, to 7 or 8 or 9 pages, something of that sort. But in fact, we put the offending evidence together in attachment A to the application. That's at bundle 2, 35. And one can see that the evidence deals with the substance of the allegation.
And so you say tab 35?
Tab 35 in bundle 2, yes.
Yeah, I'm nearly there. The choice of this particular design of bundle is not ideal because the centre piece is so upright. It's very little actually. Right, we're nearly there. Thank you. Right, I've got it. Attachment to application, yeah.
Yes. So we see.
Yes, well, I've read through most of this, and in particular the passages that are highlighted in yellow. So I got some. I mean, I understand the point that you're making, that there are references to key finding 13 and also to the dealings between MMG and MML and identity of violation 6. So I've
Yes,
got, I've got the point. Yeah.
It goes a little beyond that, Your Honour, in the sense that, yes, let me show you just one or two examples. If one goes
Yes, of course.
Mr. The extract from Mr. Hubbard's statement begins at 652 of the bundle.
Yes.
And then the main part that deals with MML is at paragraph 70, which is at page 656.
Thank you. Yeah, I have that.
So he then spends a number of paragraphs going into the substance of the allegation. In other words, the content of the report and the manner in which it is suggested that the report reported that these payments were suspicious. One notes in passing at paragraph 70 that he purports to do so by slightly unusual and detailed analysis on the part of the factual witness of pleadings. I'll come back to the supposed justification in a moment. But then he goes at 71 and following, deal with key finding 13. And I know Your Honour has read this, but I summarise it by him describing the investigation. At 76, he says that me and my colleagues investigated the relationship with MML. Mr. Cassie led as part of the investigation. I defer to the detail. And he describes why he suggests that these were all suspicious payments. Again, in 77, 78, he refers to Mr. Cassie as far as the detail is concerned. And it's perhaps Mr. Cassie's evidence that is of most concern. In fact, the extract starts at 659, and again, there are one or two passing references to MML, but the nub of it is at paragraph 33 and following, at page 663 of the bundle. And again, Mr. Cassie provides an analysis of our pleading by reference to subparagraph 121bf, and then goes on to refer to key finding 13 in the report and to describe the various transactions and investigations that went on. And importantly, Your Honour, he refers, for example, at paragraph 37, at the bottom of 664, I recall the transactions that did unusual for a number of reasons, reportedly for material purchase of equipment, and he goes on at the bottom. Moreover, as identified by Mr. Mehta, or a member of his investigation team, MMG's own internal audit team had on 30th of November published a special internal report in which the second claimant, as the chairman of the Board Audit Committee at the time, was in fact copied, which was, however, not presented in the annual Audit Committee presentation given in 2009 that included the agreement and the transactions with MML at question. So there he's saying that the second claimant had actual knowledge of these particular matters. There is at least the implicit suggestion that notwithstanding identification of this concern in an internal audit report, there was a failure by somebody to include it in an annual Audit Committee presentation. Further detail given over the next few or so pages. We see once again paragraph 46, beginning at the bottom of 657.
Yeah.
The team also found an internal audit report, which had been prepared by the chief internal auditor. Since left the company, he was sustained conclusions Protiviti had. The report notes in particular there are no valid supporting documents. He goes on to say at the bottom of that paragraph, this report was addressed to the President and CEO of MMG, Nicholas Al Khoury, copying the Chairman of this Board Audit Committee, with a second defendant, again, so an allegation that a further document was known about, or at least sent to or addressed to one of the claimants. He then goes on to express his view as to the nature of these payments. They were suspicious, highly irregular, non-transparent, deserving of further investigation. In short terms, he effectively said that appears to say that someone was paying bribes to a particular transaction party on the basis of this evidence. And he then, at 61, at page 669, when referring to various lists of individuals that were identified in an email to Mr. Mehta as being individuals that the CMA may wish to interview, that included the claimants. He justified that about 2/3 of the way through that paragraph. It says, thirdly, with regards to the second claimant, during the course of the MMG investigation, he observed he had in fact been involved in various communications which identified certain transactions and claims as suspicious and problematic. For example, the financial payments made by MML to MMG between September 2008 and August 2011. And he says, and up to this point, I took the view the above factors provided adequate grounds for listing the claimants as individuals the claims that the CMA may want to interview. So the point is, Your Honour, that this evidence does not simply refer to MML in passing by way of on the way to investigate violations 1, 2 and 4. I happen to pass by violation 6. They go in the detail to the substance of alleged violation 6, as well as expressing views as to whether or not that the claims made in the report in relation to that violation were well founded, and in doing so also cast implicit criticism, at the very least implicit criticism, perhaps implicit criticism, at the door of the second claimant by saying that he was aware of certain communications of which he was chairman for a time. So thereby it said had knowledge of relevant matters, and it said there was some, or at least it appears to be said, that there was some sort of failure to raise at the appropriate time in the annual report. So, Your Honour, there are, we say that these are significant points. I mean, that they certainly appear to make allegations of wrongdoing against somebody, perhaps more than one person, perhaps people who are not parties to these proceedings, but they appear to be explicit or not in relation to the mail matter. So for those reasons, I said, if left to remain in the evidence, these are matters that my client would feel obliged to respond to by way of at least some substance in order to dispel the insinuations that appear to be made against him. Now, there have been a number of purported justifications for including this evidence, and we, with respect, do not consider that any of them are persuasive. The first point, as you have seen from both Mr. Hubbard's and Mr. Cass's witness statements themselves, it said that these points are relevant to a particular part of our pleading, a sub-paragraph 121BF. So perhaps I can ask you to put away bundle 2 for a moment and go back to bundle 1.
Yeah.
And the relevant paragraph is bundle 1, tab 7. And it is page 122 of that bundle. And the page 122, little f, is the paragraph that it said justified the inclusion of this evidence. Well, just to put that paragraph in context, it begins at page 118 and this is section F of the pleading, gives particulars of loss and damage. It goes on at paragraph 120, the CMA issued proceedings on the 18th of November. 121, subsequently, on around the 16th of June 2016, the CRSD judgment and imposed various penalties. But then at page 120, paragraph 121B begins with the words, in addition to the above, and various other matters that are referred to, some of which have been deleted. And F says that based on the defendant's wrongful accusations of alleged violations of Sandy Company's formal report, those accusations were subsequently used in a charge sheet. The Ministry of Commerce and Industry instructed the Bureau of Investigation and Public Prosecution to initiate proceedings against the defendant. So it said that, this evidence is directed towards rebutting the accusation of wrongful accusations. But, Your Honour, we say that can't realistically be right, because when F refers to wrongful allegations of alleged violations, then read sensibly, that must be a reference to the complaints of wrongful accusations of alleged violations that remain in a particular claim. So in other words, violations 1, 2 and 4.
Yeah.
Particularly when, of course, when both sides have, firstly, when the defendant has incorporated in its defence paragraph 67(2), in other words, nothing that is not relevant to violations 1, 2 and 4 is relevant to this claim, and in circumstances where both parties...
What they're doing is they're removing the points they wish to raise to the extent that you were relying upon violation 6. So when you removed any reliance on violation 6, they could remove from their defence any response to it. It wasn't needed anymore. But that's all that was happening. There's no sort of agreement that violation 6 is of no pertinence to the case at all. It's simply saying we don't need to defend your complaint that we got violation 6 wrong because you no longer say we did.
Well,
I mean, any more than if they simply, suppose they abandoned violation 1, there would be nothing, supposing you've abandoned violation 1, nothing to stop them relying upon violation 1, is there?
Well, if they were to plead an allegation that rendered violation 1 relevant, notwithstanding...
No, they might not. They might want to plead, I follow, that your abandonment of violation 1 rather gave the game away because you, in fact, that was the cause of the problem, and therefore that they could simply rely on it as some of the what I call circumstantial material relating to the way in which the company had been conducting business, and this investigating company had carried out an investigation. I follow that the scope of the inquiry is not easy to draw a very clear line on, but the mere fact that they have removed from the defence any defence of the allegation that violation 6 was causative of loss doesn't really take one anywhere, does it?
Well, what they have done, Your Honour, is firstly to positively plead that the only content of the report that's relevant to the claim is those sections of the report which deal with violations 1, 2 and 4. But then they have removed all allegation about in the defence as to the basis of their findings of potential wrongdoing. Now, because I accept...
but I mean, if all your clients had spent all of this time in prison, they could raise that point, couldn't they? Even though it was irrelevant to the actual issue of fact.
Well,
In prison for some fraudulent activity.
Well, you're right. I think it runs this way, that if notwithstanding the fact that no complaint is now made about violation 6, and therefore no justification of the report in relation to violation 6.
Well, no complaint is made about violation 6 because you accept that the Saudi authorities paid no attention to it because it had nothing to do with the relevant period with which this company was conducting its business and these people were investigating. That's all it establishes, isn't it?
Of course. My point is, Your Honour, that if the defendant seeks to argue that notwithstanding that has been taken off the table so far as a complaint against the defendant is concerned, it is relevant to the remaining claims, and this is the thrust of much of what is said in my learned friend's skeleton. For example, it said, well, even if you no longer complain about violation 6 because no finding was made by the CRSD, it is of relevance because it forms part of the basis on which we were entitled to find that there was a potential potential dishonesty or misrepresentation on the part of your client. And similarly, it suggested, again in skeleton, in relation to this subparagraph F at page 122, that, well, we're entitled to argue that notwithstanding that violation 6 has been taken off the table by way of complaint, that it was relevant and nonetheless you would have been investigated and or proceedings would have been commenced in any event because of, inter alia, violation 6. Now, one can see the superficial attraction of that, but the key point is, Your Honour, that if that is a claim that is going to, if that is a point that is going to be advanced, it must be pleaded. It is not good enough simply to serve evidence that says, well, notwithstanding violation 6 not being a part of the allegation against the defendant now seeks to give evidence of the substance of violation 6 in order to prove, and I paraphrase, in order to prove that, well, the claimants were had acted poorly or wrongfully, or there was some general grounds for inferring dishonesty on the part of the claimants in any event. In other words, we would have come to the same conclusion in any event because you were in some way tainted by this MML issue, or you would have been investigated by the Bureau of Investigation and Public Prosecution in any event. That's the thrust of the point. Now, if it is really said, and frankly, we don't see how this point could respectably be put. If one looks at the evidence that is sought to be adduced by these witnesses, really what they don't get anywhere near to supporting a clear pleading that my clients, or the complainants in particular, were sufficiently tainted by the MML investigation so as to found an allegation that he would have been investigated in any event, or that the conclusion in the report that there was a maintainable or a potential claim against him of fraud or misrepresentation was in any event justified, leaving aside the content of violations 1, 2 and 4. Those are matters, those are very serious matters. If that really is going to be a point raised against my clients, those ought to be pleaded. They ought to be pleaded in the usual way with proper particularity, and they haven't been.
Yes,
so,
thank you.
That's why I call it a superficial attraction. One can see how a point like that works, but only if your evidence is good enough such that you are able and do plead the point against the party against whom you're seeking to make the point good. So, the same sort of point applies to a number of points raised by the defendant. Your Honour, one is the one that I think is made at paragraph 34 of the defendant's skeleton, which goes to this. In the particulars, that there's a similar point is made at 31A, which again purports to suggest that the conclusions in the report were in any event justified by reference to MML. And just, I appreciate Your Honour won't be familiar with the report as yet, but Your Honour ought to see, going back to the report itself, that there were these very, very serious, as we characterise them, allegations made against my client. If I can ask you to briefly go back to the supplementary bundle, back to the report itself. I've shown you Honour the key findings, but looking at page 23 of the bundle, one sees that there is a heading entitled Potential Actions, and two-thirds of the way down the page, Abdul Mohammad Bin Abdul is mentioned. He is the second claimant, my client. First, a non-executive director, 5% shareholder, chairman of the board, been involved in the following key findings identified. The audit committee chairman was made aware of an internal audit report, appears to have agreed a compromised schedule of payments, was made aware of MMG's poor profit status, ultimately responsible for ensuring that all information contained in the prospectus reflected the true position of MMG. Potential civil and/or criminal actions that can be taken include fraud, misrepresentation, misadministration of the company's affairs, wrongful action towards the shareholder, several contraventions under Article 229, including, and then one sees at the second bullet point, knowingly providing false information in the financial statements with the intention of concealing the financial position of the company. So these really are, now, I hasten to point out that the defendant, the report contains significant caveats, sufficient caveats to mean that these weren't actual allegations and therefore weren't conclusions drawn as such against my client. But those potential actions are the ones that were mentioned in relation to my client. You'll understand that, bearing in mind the evidence that you've seen in relation to MML, in other words, these short references, comparatively short references in the witness statements of Mr. Hamad and Mr. Cassie, which refer to internal audit reports being copied to, or at least addressed to, the second claimant. It really were to be suggested that the conclusions drawn, in other words, the identification of the second claimant as somebody potentially in the firing line for dishonesty and intentionally manipulating financial statements, the defendant would have to do rather better the evidence that you've seen. It really is to be suggested that MML, this subject matter, was the basis upon which an investigation that MML justified a potential offence of dishonesty in the way mooted. But a similar point arises. You've seen Mr. Cassie and Mr. Hubbard, just to close the point off in relation to the evidence. Your Honour, going back to bundle 2, and I apologise for putting between bundles. Back to tab 35 once more. We see that Mr. Mehta, his evidence is very short. It begins at 670 of the bundle. At paragraph 196, that I referred to, paragraph 80, the re-amended particulars of the claim, in which the claims refer to paragraph 24 of the report, where the report referred to potential action that might be taken against the second claimant. So this is when he's referring to page 24 of the report. That's the page I just showed Your Honour, relating to potential actions to be taken against. And the second bullet point is the one that he quotes in italics in the fourth line of that paragraph, knowingly providing false information in the financial statements. This reference in the report is not related to the failure to impair vessels. I pause there to note that paragraph 80 is in the section of the particulars dealing with asset values, nothing anything else. And he says that I believe this reference in fact relates to the findings made by the team looking at the MML issue, where there was at least one email addressed to the second claimant. So again, this is, as we would characterise it, Your Honour, really weak stuff. If it really is being suggested that the allegation in the report that one of my clients knowingly provided false information in the financial statement is justified by reference to the findings made by the team looking at MML, then the defendant would have to do very much better than this evidence that you've seen, and would have to properly plead the allegation that there is simply no proper evidential base here to make such an allegation, and it would have to be pleaded with utmost particularity, we would say, in the usual way. So that's the witness statements themselves, Your Honour. That's the purported justification within the body of the witness statement. What then happened, as I'm sure you know, is that my clients wrote to the other side on the 14th of December, so shortly after the witness statement was served. That letter is at tab 38 of the bundle 2.
So repeat the reference, please.
It's bundle 2, tab 38.
Thank you. Yes, well, I've read these letters.
Yes.
Yeah.
Well, so I won't these will go over what was said in the 14th of December letter. I simply really refer to the Clyde & Co response, tab 39, Your Honour, because these were different justifications. You've seen the justifications that were included in the evidence itself. But there were the new justification put on the 21st of December was this. The claims have made a root and branch attack on our client's motives, professional competence and integrity. Therefore, it's important for the court to understand the broader context of the MMG investigation, not just a handful of points on which the claims are choosing to focus. Well, again, my Lord, it's not clear to us how this supposed broader context is going to assist the court in circumstances where, as I say, there is not just a passing reference to MMG, there is reference to the content. And the substance of the allegations, along with conclusions drawn by witnesses. And it goes on then to say, it provides an example of the care and conscientiousness with which the defendant carried out its brief. Is artificial for the claims to seek to limit that. Well, again, we struggle with that, Your Honour, because if the court were going to be assisted by simply examples of good work that the defendant has done, then why restrict it to this report? Why not give examples of a fabulous report produced a year previously or 2 years previously? What the court's engaged upon is working out whether the matters which are the subject of the complaint were properly researched and justified, not whether the defendant can provide an example not relevant to the claim of where it says it carried out conscientious or careful work. So we suggest that the separate and new justifications put in this letter are not persuasive. But there are a number of these points are replicated, of course, in my own friend's skeleton. Just to pick up on one or two further new points or separate points that are raised in the skeleton by way of justification. There's a suggestion at paragraph 28 or thereabouts of the defendant's skeleton that we're seeking unilaterally to measure the scope of the well, not really. What we are trying to do is to restrict evidence to that which is relevant to pleaded issues. So this is not some sort of unilateral exercise on our part. We're inviting the court to consider what the issues are and the extent to which it's going to be assisted by such evidence, and if not, circumstances where it causes us significant practical difficulties to exclude it. Next point that's made is that this is somehow a disproportionate exercise. There's only, I think the defendant has sort of totaled up all of the extracts and put them together where they said there's only 7 odd pages of this evidence, but Your Honour has seen the evidence itself. It's significant. It does descend to the substance of this allegation that was contained in the report, albeit not in a huge amount of detail. Once, and it said, of course, that this is disproportionate, perhaps backing out, and that the court could simply leave it to deal with the trial. But again, Your Honour, the difficulty we have with that is that it puts us to significant inconvenience and work in order to respond to this. There is a significant story to tell in relation to MML, as you've seen from the now deleted pleadings. We would have to deal with questions of the knowledge and or interference of our clients to rebut these, what seem to us to be in principle, at least doing in circumstances where, once again, there's a very tight timetable. But very briefly, I'm being conscious of the time. There's a suggestion at paragraph 31D of the skeleton that it's relevant to. There's a minor dispute between the parties as to the extent of involvement of Mr. Paget, Simon Paget, who was a Protiviti employee, or at least who worked with the defendant's umbrella organisation. It may be right that there's little harm in the very full passing references given in Mr. Mehta's statement, where he says, "I recall that Mr. Paget was involved with MML," but really that's not the substantive point of the application. It is the application's purpose to deal with the substance of this MML allegation, the evidence which goes into the detail of it. It's suggested at paragraph 33 that this provides a good indication of the difficulties encountered in obtaining documents. Well, it doesn't seem to us that one needs to go into the substance of this MML transaction, or that part of the investigation, in order to give an example. In any event, it doesn't seem to us that there were difficulties obtaining documents relating to MML. Not clear to us how that is relevant to any flaws or alleged flaws relating to violation of 2 and 4. There's a pause for the goose point, paragraph 35, where examples are given of my client expressing his view that the defendant did not undertake an independent, genuine fact-finding exercise, but was building a predetermined case. And say, well, they'll let that go. The fact is that significant quantities of their supplementary evidence does deal with these sorts of allegations. And in fact, the reality is that this doesn't deal with, this is not a matter, in any event, that my client's evidence is not relating to the substance of the report, as opposed to simply his view as to what might have led to failures. And finally, Your Honour, there's this point about narrative relevance. We accept, of course, that there are examples in the cases and in Fixon where where a piece of evidence, while not necessarily directly relevant to the resolution of an issue, may nonetheless be admissible as part of telling the story. And the example cited in Pipson is that a witness to a town centre murder explains that he was going to town to buy a shirt. Well, we don't take issue with that sort of evidence. No doubt in that example, the reason for going to town is not in dispute. That is very unlikely to be. Is unlikely to engage the court or either party in significant time dealing with the matter. But by contrast, of course, this MML issue is not just some passing reference. The evidence deals with the substance of the allegation in the report, a matter which has been in the past, which has been removed from and about which there is significant controversy. So, Your Honour, to summarise, we think this evidence is irrelevant. We think it's unhelpful. We understand the court's instinct that sometimes these matters are best left to trial. But in light of the matters I've shown you and the significant unnecessary work that it will force to undertake in a tight timetable, and indeed, given that what everyone acknowledges is a very tight timetable at trial, it does seem to us that this does further endanger the orderly running of this trial. We suggest that it is appropriate to exclude this evidence at this point. Your Honour, unless I can assist any further, I will. That's all I wanted to say for now.
Thank you very much. Yes, Mr. Brockway, just can you deal with the spikes that struck you as requiring a response?
Sorry, my Lord. Yes, I will indeed. The summary of my submissions, Your Honour, is that your initial reaction was the right one, that it's not appropriate to shut this evidence out, and that to the extent that any point needs to be made about it, it can be made at trial. Can I just make 2 points, very short points on timing? I don't want to pursue any argument that Your Lordship shouldn't, that Your Honour shouldn't hear this application, but it is made very late, without any explanation. And the significance of that in my submission is that the claimants now say, well, one of the reasons why Your Honour should shut this evidence out is because there could be knock-on implications for the timetable. And I say that's completely backwards. This evidence is in unless until it's excluded. The claimants were required when it was served to deal with it, to the extent they wished to, either by answering it, if they felt the need to do so, or by making their application forthwith. What they can't do is what they've effectively done, which is to threaten an application, then delay in making it, and now say, oh, well, it's all very late, and that causes us difficulties. So, my Lord, Your Honour, I do say you shouldn't be influenced by that part of Mr. Head's admissions. Your Honour, it's already taken far longer today to talk about the MML issue than it would have done for Your Honour to read the evidence and order it at trial. And there is an irony in my own friend's skeleton suggesting that it shouldn't have to take up court time in circumstances where that's precisely the effect of this application. Now, I do want to say that one of the key ways in which the claimants go wrong in their application, and this is common with their approach to the case as a whole, as we'll see when we get to trial, is their idea that everything is about them. And when we get to trial, Your Honour, we will see that the claimants repeatedly mischaracterise Protiviti's report as being entirely or principally concerned with them as individuals. And in fact, it was nothing of the sort. And much the same self-preoccupation appears to underlie this application. What Protiviti has done, to be clear, is to explain its work on MML as part of the defence of its work on the report overall. It is not about the claimants at all. It is about what Protiviti did and why they do. And the claimant's application, I suppose, is based on a misconception that this is some sort of attack on them. But that's wrong. The reality is the other way around. The claim has been brought against Protiviti by the claimants. Protiviti is adducing this evidence, amongst others, to defend itself. And so the claimants can protest that the ML issue is not relevant to their claim. But the fact is it is relevant to Protiviti's defence, and that is enough. So, Your Honour, I did want to, my learned friend didn't deal with it orally, but I did want to reject the suggestion in his skeleton that the purpose of this evidence is somehow to create what he calls a whiff of corruption, or in some way to influence illegitimately the court's mind. It's not the purpose of this evidence, and Your Lordship should, Your Honour will set aside the emotive language that the claimants use to try to characterise this evidence, because in my submission it's simply not helpful. Your Honour already has well in mind the point that this is a very limited amount of evidence. 7 pages out of 280 pages of witness evidence. And the application is a disproportionate waste of your court's time. Your Honour has seen the passages from Mr. Metz's statement, for example. His statement, in full, is 81 pages long. And my learned friend invites Your Lordship, Your Honour, to exclude 4 part sentences, running to 48 words. And I do say that's really not what the parties should be doing, and it's not a good use of the court's time. It also, my submission, suggests a lack of faith in the trial judge's ability to receive the evidence and to give it such weight as is considered appropriate. And I don't intend to prejudge at this stage what assessment Your Honour will ultimately reach in relation to this evidence. But I do say that it is relevant to the pleaded issue, and certainly arguably. And that brings me very briefly, Your Honour, to the test. I know friend accepted that it was a demanding test. I submit that the appropriate test, supported by authority, is that Your Honour should only exclude evidence if you can be sure now that it will not be of any assistance. And Your Honour has already made the point, I don't need to labour it, that the prejudice in shutting it out is far greater than the prejudice in admitting it. And I submit that's the right approach to take. Your Honour, can I just very briefly show you one of the authorities my learned friend provided the court yesterday? I hope Your Lordship, Your Honour has Wilkinson and West Coast Capital.
Sorry, what's the name of the case?
Wilkinson, Peter Robert Wilkinson and West Coast Capital.
No, I don't have that. So what's the proposition you want to advance?
Can I read Your Honour a passage? It's such
Well, you can, if you tell me what proposition what's the proposition you want?
The proposition is that the test be applied at an interlocutory stage is that evidence should only be excluded if the court can be sure that it could, on no conceivable configuration of the hearing at trial, could it be relevant or of assistance.
Well, I don't think that's controversial.
And I can briefly deal with relevance, Your Honour. And I should say, by way of introduction, that I don't accept the way in which my learned friend has characterised or paraphrased some aspects of our case. And put that more concretely, can I give you some examples of why we say this material is relevant?
I'm sorry to interrupt. Apologies. The sound system is awful. I'm having very great difficulty in hearing you, A, because your voice is distorted. It's not your fault, the voice is distorted, but it also is accompanied by an echo of your voice, which is pretty horrible.
Yes.
Anyway, just bear that in mind. Listening to you is quite, not because it's you, but it's quite painful, I'm afraid. So you'll have to...
Your Honour, I'm very grateful for that feedback.
Yeah. Anyway, we're certainly not going to use this system in the hearing, I'm sure. Right.
If it's difficult, is there any value in us taking a short break and seeing whether we can improve the connection?
Well, that's all immediately better for some reason. I'm not quite sure how. Thank you for that.
Right.
So let's just see how we get on.
I'll press on. Can Your Honour take bundle 1, please? I'd like to look at the pleadings.
Yeah.
In particular, tab 7. This is the re-amended particulars of claim.
Yeah.
And within that, page 103. Now this is part of the claimant's pleading in relation to alleged violation 2. But what they say at paragraph 80, specifically, in the second half of the paragraph, is a sentence that begins on the basis of the above. On the basis of this alone. It is inconceivable how the defendant reached the conclusions, and then A is set out at pages 23 to 24 of the report, that action could be taken against the second claimant on the basis that he knowingly provided false information, etc. And my learned friend showed you in the report where that was found. But the point for the purposes is that claimants are criticising my clients in relation to that statement. And part of Protiviti's response is to say, you, the claimants, raised this comment in the context of violation 2, but it was not in fact addressed to violation 2. That was not what Protiviti had in mind when it wrote this in its report. And you'll see that if you go to tab 8 in this same bundle. To page 167.
Yeah.
In paragraph 84, we are addressing paragraph 80 of the re-amended particulars of claim. And if Your Honour casts your eye down to the underlined passage, it says, without prejudice to the generality of that denial, it is specifically denied that the words knowingly provided false information, etc., were directed in the report to the asset valuation which is in question. That we are denying that it's to do with the thing that the claimant says it's to do with. So one might naturally think, in the context of that dispute, that it was open to my clients to give evidence as to what they were referring to when they made a statement that is criticised by the claimants. And that's exactly what Mr. Mehta is doing in his witness evidence, at paragraph 196. In the interest of time, I won't take Your Honour back to it, but it's at bundle 2, tab 36, page 672.
Yeah.
And the claimants may say that they disagree with that. They may say they don't accept that explanation. They can't possibly say that that evidence is inadmissible. And both my learned friend's skeleton and his oral submission seem to suggest that because the claimants characterised that statement from the report as being about violation 2, the defendant was only able to give evidence in response that dealt with violation 2. That can't be right, because part of our response is that they are wrong to characterise it in the way in which they characterise it. That's what the evidence is going to. And so, if Mr. Nato is going to make that, which plainly in my submission is entitled to do, it's also going to be helpful for Your Honour to have evidence of limited scope, which is what this is, explaining what the MML issue is, so that Your Honour can then judge for himself whether this statement in the report, which is criticised, was referring to MML or was referring to something else. Your Honour, the next point I wanted to show you, because it's of some importance, is paragraph back in the particulars of claim, so tab 7, page 115. And Your Honour will see a heading at the bottom, proposed offences against the claimant. And the claimants are going to go on to criticise parts of the report in which Protiviti suggested that the CMA might consider taking certain steps in relation to the claimants. And I particularly wanted to refer to paragraph 115 on page 116.
Yeah.
Where you'll see some what purport to be quotations from the report. And what the claimants are going to go on to do in paragraph 119 and 119A is to treat those statements as part of the basis for their claim. Now, Your Honour, looking at paragraph 115, might reasonably say to himself, well, what's this got to do with MML? I can show Your Honour that by taking up the third bundle. If Your Honour would keep that bundle 1 open and take the supplemental bundle, please.
Yeah.
And in the report, which is tab 1, can we go to page 23?
Yeah.
Your Honour was shown this briefly by my learned friend this morning. But in the passage Your Honour was shown, Your Honour will see various bullet points, starting with has been Audit Committee Chairman since February 2008. And what I'm inviting Your Honours to do is to compare those bullet points with the quotations in paragraph 115. They are broadly the same, but whereas the report, as in the second bullet point, was made aware of an internal report on MML, and the questionable claims to MML, in the pleading, for reasons that have never been clear, that has been mistranscribed as the company. And the same is true in relation to C, where the company should in fact read MML. Seems that even at the early stages of pleading their claim, the claimants had some sort of aversion to any mention of the letters MML. But what is in no doubt at all, Your Honour, is that they are pleading reliance on statements in the report which squarely relate to MML. And now they tell Your Honour that you should exclude evidence going to justify those statements. And in my submission, that's self-evidently unfair and inappropriate. And what the claimants are criticising is they're criticising my clients for having identified the second claimant, amongst others, as somebody to whom the CMA should speak in considering whether to take further action. And this is relevant to the evidence that Mr. Cassie gives. Your Honour can take up bundle 2. Tab 29 this time, please.
29.
29.
Yeah. Did you say 29 or 39?
29, Your Honour.
Yeah, I got it.
29.
Yeah.
This is Mr. Cassie's statement in full.
Yes.
And if Your Honour goes to page 562,
Yeah.
there's a heading towards the bottom of the page, the report.
No. Sorry, what page again?
562.
Oh, 62, sorry. Yeah, got it.
The report. And Mr. Cassie is explaining that part of his role was to give input to the content and structure of the report. And in the second sentence, he refers to an email that he wrote internally as part of that process. And he says towards the bottom of the page, I also provided my input as to the individuals at MMG that were to be listed in the report as being individuals that the CMA may wish to interview in connection with their investigation into MMG. And so the connection here is that the claimants say in their claim, well, you shouldn't have pointed the finger at the second claimant. And one of the reasons why the finger, to the extent the finger was pointed at all, the finger was pointed to the second claimant, was because Mr. Cassie suggested that it should be in this email that he's going to go on to talk about. He then does go on to talk about it and to explain his thinking in the remainder of paragraph 60 and in paragraph 61. And I won't take Your Honour to the redacted section, but that's when my learned friends instructing solicitors get their red pen out and start saying, well, he can't explain this. Or at least he can only explain it if he refuses to mention the word MML. And so my submission is this. This material is plainly relevant to the criticism which are made by claimants, and it is a legitimate explanation of the part that Mr. Cassie played in producing elements of the report that are squarely in issue in these proceedings. And if Your Honour was to accede to the application to shut out evidence from Mr. Cassie to that effect, you would in fact be hamstringing Mr. Cassie from explaining truthfully and accurately his role in the investigation. That will be wrong at trial. It is doubly wrong at this stage. My Lord, Your Honour, I can deal with just one other point on relevance, and I will leave the remainder, although there are more, and that is the causation point in relation to paragraph 121b of the re-amended Particulars of Claim. Again, I know if I showed you...
Sorry, you'll have to say, I couldn't hear you then. Paragraph what?
121b of the re-amended Particulars.
Yeah, thank you.
We are back in bundle 1, tab 7.
Yeah.
Page 120.
I have it.
The heading at page 120 is further losses. These are alleged losses suffered by the claimants, in addition to the amounts that the claimants were ordered to pay by the CRSD. And the punchline of this paragraph in the re-amended Particulars of Claim is going to be at G on page 122 that the matters pleaded here give the claimants an entitlement to general and special damages for reputational harm, distress and inconvenience. And we say that's misconceived for a number of reasons. But it is the pleaded case. Now, my learned friend got it wrong when he told you what the point was here. So can I just briefly try to explain what the point is and why we say it supports the relevance of the evidence we're talking about? One of the factors relied upon by the claimants as supposedly giving rise to this entitlement is in F, in the middle of F, proceedings brought by Bureau of Investigation and Public Prosecution in the Kingdom of Saudi Arabia. So the argument by the claimants is those proceedings have been brought against us, and they, amongst other things, have caused us loss of reputation, mental distress, and other intangible losses. Now, those proceedings are understood to be ongoing, and among the matters being investigated in those proceedings is precisely the MML issue. This is not a question of us saying, as my learned friend put it, that the claimants would have been investigated in any event for MML. They are being investigated. So what we say is simply this. To the extent that the damage to reputation, etc., relates to the Bureau of Investigation and Public Prosecution proceedings, those are related to a matter which the claimants do not criticise Protiviti for, namely MML. It's essentially a but-for causation. We say some of the things that happened to you that you complain about were caused by factors that you cannot criticise Protiviti for. And that's the point. Well, I won't deal with Mr. Paget, because I think my learned friend was effectively conceding that the evidence dealing with Mr. Paget couldn't be excluded, although it's included in their application. Very briefly on the illustrative value of the evidence. The terms and the tone of the attack on my clients in this action are such that it's appropriate for Protiviti to defend itself, at least in part, by saying the areas that you focus on are only one part of what we did, and we also did work in other areas that provides further support for our diligence and competence. We've given Your Honour references in paragraph 35 of our skeleton to some very heated language used by the second claimant in his witness statement to criticise the work that we did. If that's the way the case is going to be put, it can't be suggested that we should be shut out in providing further examples of the work that we did and how we went about it. Now, accept that if this was the bulk of our evidence, or even a substantial part of it, that might be problematic. But it is a tiny fraction of the whole, and we say it is helpful and relevant for that further reason. The last point on relevance, Your Honour, is that the reductions are misconceived because they cut out narrative context. Can I illustrate that by reference to Mr. Hubbard's statement? In Bundle 2, tab 35, page 655. And at the top of the page, Your Honour starts partway through a paragraph, but he, Mr. Hubbard, is talking about an email that he sent internally partway through the investigation. And he's explaining what he said in it. And in the course of that explanation, he refers to his thinking and what it was based on. One of those bases, as Your Honour sees from the highlighted part in the middle of the top paragraph, was MML. Now, the claimants want to redact that reference. But without it, Mr. Hubbard can't explain what he was saying. And I do say it is going too far to say that every reference to a part of the witness's thinking has to be tied back to a specific pleading. That's not how evidence works. Of course, as a whole, the evidence has to go to the pleaded issues. But this approach really doesn't make any sense, and it risks making a nonsense of the evidence that the witnesses are trying to give. Your Honour, one last point of substance, and that is that there is absolutely nothing in the pleading point taken by the claimants against my clients, in the effect that we said that this was irrelevant. When we said it was irrelevant, that was, and always was, a point about causation. The point was this: if the CRSD did not find claimants guilty in relation to issue X, then Protiviti's report in relation to issue X cannot have caused loss. We were not saying that issue X then becomes beyond the pale or inadmissible for all purposes. I won't take Your Honour to the pleadings to make that good, but it's quite clear on the pleadings that that's the context in which we were running that point. And Your Honour, just for Your Honour's note, we'll see that in particular at what's now deleted paragraph 94 of the defence, which is in bundle 1, tab 8, page 171, where we said in terms that it was irrelevant because it couldn't have caused loss. If Your Honour's looking at it, it's paragraph 94, deleted. And we say that the CISD didn't make any adverse finding, and about 3 lines down at the end of the 3rd line, in the premises is denied that any work done or statements made can have caused loss to the claimants. That was the point. We weren't saying, right, no one must now speak of MML ever again. And as I've shown, Your Honour, because of the way the claimants plead their case, MML remains relevant. And to that extent, and only to that extent, our witnesses have given evidence for it. So, in summary, my submission is that this evidence is relevant and admissible, or at least strongly arguably so. There is no safe or adequate basis for shutting it out, and Your Honour is invited to dismiss the application on that basis. And I should say we resist the idea that claimants should have another bite at the evidential cherry. They have made the choice not to respond to this case, and that's the choice they should do. The evidence was, as I said at the outset, in until excluded. Claimants weren't entitled in the interim to assume that they were right and that it would be excluded. It wasn't, and in my submission it shouldn't be. So in what is, as my learned friend has already said, a timetable, I submit that their misconceived application should not be allowed to put further pressure on the timetable. Obviously it's ultimately a matter for your lordship, but that would be our position if you're, as I submit you should, Your Honour dismisses this application. I apologise for the sound problems, but those are the submissions I wanted to make.
Thank you. Just hang on a moment. I'm going to have to take a short break. We'll resume in 5 or 10 minutes, please. Okay.
All rise.
I'm just going to redial the connection.
That's fine, thanks.
Can you hear me okay?
Yes, we can. Could you please say some things to test it?
Testing. Testing.
It's slightly worse than it was before, if that's possible. Could I ask in terms of acoustics as well, we're getting some level of reverberation, if there's any ability for the reverb to be turned down on your end?
How about now?
The acoustics are a little better, I'd say. The acoustics are a little better, I would say. The video feed is still interrupted and glitching, unfortunately. I'm going to get Ijaz on our end to come and liaise with you because you can possibly speak about settings a bit more thoughtfully when he's here.
Yeah, that sounds good. Hopefully we can make it a little better. The video on our side is pretty good.
Okay, understood.
It seems the signal's breaking up.
Hello,
Hello.
this is Ijaz. So Derek was saying there is some technical going on.
Right, well, you know. Can you hear me okay?
Yeah, it's fine. Okay, do you have something? Can you read something so that I can?
So could you repeat that, please?
Yes. Do you have anything there to read? Can you read something, some big paragraph, so that I can, see is there lagging, the mics are lagging or something?
I haven't got anything to read. Got any lines?
Yeah.
Interesting to read.
No,
Because they're standing next to each other with the microphone.
no.
There may be a very large request
Close to the
disclosure.
Can you come little forward, little closer to mic?
Forwards. Sorry guys, just make sure that volume's okay. I'm going to read some very fascinating paragraphs. When possible, any dispute about the parameters of any electronic search should be referred to the court for determination before the relevant search is carried out.
It's a lot better now, I believe.
Yeah, a lot better. Because our mic is here.
Yes.
So, what about the video quality? Because ours got a little bit better.
Council to speak this slower and emphasise their diction. Thank you. Would you just remind everybody on your end that because of the fade-in, fade-out nature of a microphone, it's important to speak a bit more slowly and emphasise diction. Obviously, you can't speak as quickly as you might in person. That will assist the judge. On that note, could I ask if counsel in London is ready to resume?
The mic's here. If you need to move it, you can. It's got a long cable on it. Okay.
Do we have counsel ready in London?
We do. Apologies for the delay. We're ready to go.
Thank you. Is counsel ready in Dubai? Thank you. All rise.
Yes.
Your Honour, we have re-established the video connection. I hope that it may have been improved in its quality, but I don't know if we've been successful.
Yeah, the picture is better. It was all breaking up. The sound is pretty awful, but I'm told that that's your end. I'm not your office, but London is notorious for having very poor video connections. And
It may simply
let's
be
see how
our
we get
voices,
on.
Your Honour, for which I apologise.
Yeah.
Your Honour, just a few short points by way of reply, if I may.
Yes.
The first observation is there has been, with respect, very little attempt from the defendant to justify the substance of the MML matter being dealt with in this evidence. as we hear, we don't understand there to have been any oral justification at all. The particular passages to which you've been referred are what might arguably be varieties of narrative relevance. In other words, Mr. Mehta simply explaining in paragraph 61 of his witness statement that the reason for inclusion of certain people in an email was the MML matter, or Mr. Hubbard at paragraphs 33 and 34 simply mentioning MML in passing. But the real vice of this evidence, we do object to all of that evidence in our application, as you know. But the real vice of this evidence is that the substance of the MML matter is raised in this evidence, and these witnesses seek to deal with it, including by raising matters of knowledge and/or involvement on the part of the second claimant and others. And it is that which we're principally concerned about. So, of course, the point is put, well, just because the content of issue X, as it was described, that the MML matter has been deleted from the pleadings, doesn't mean it's irrelevant for all purposes. But again, that may be the case, but in those circumstances where you say that a particular issue or the content of a particular issue is relevant to another issue, then you should plead its relevance and explain precisely what, how the substance is relevant to the complaints that continue to be made against the defendant. As things stand, we're left with this slightly odd position. I will invite you to look at a footnote in my learned friend's skeleton argument at page 10, where it said that, footnote 2, bottom of page 10.
Here we are, yeah.
At page 10, footnote 2, we see that for the avoidance of doubt, Protiviti does not say that the court should infer fault on the part of either claimant in relation to alleged violations 1, 2, or 4 from anything relating to the MML transaction. So there's confirmation there that the MML transactions are not intended to infer fault against either claimant, but still we have the tension between that, in relation to those particular alleged violations, but we have a clear tension, we would say, between that confirmation and the suggestion that the MML matter is relevant to these broader questions as to whether the conclusions in the report were justified against each of the claimants, including the potential offences that were identified by way of, and potential future actions that were said to be justified against each defendant in the report itself. It's suggested that we have got it wrong in relation to paragraph 121BF, and I think the manner in which we alleged to have got it wrong is that we suggested, well, this is saying that we would have been investigated in any event. Now, a little unfortunate that Mr. Brocklebank gave some evidence before the court this morning as to the fact that there's an ongoing investigation. Again, that's not very satisfactory, Your Honour. If the point is, well, that there's no loss caused by any alleged failures on the part of the defendant because this investigation was instituted in any event and is ongoing in any event, well, again, that is a matter that ought to be pleaded. It certainly doesn't, in our submission, justify the introduction by way of the substance of the MML matter by the back door. The point was taken on paragraph 80 of our pleading. I won't take you to it, Your Honour, but you'll recall that there was a complaint in relation to violation 2. Inflated asset values, and there was a complaint that in light of the true position, as our clients characterised the true position, there was no justification for including statements in the report which suggested that certainly the second claimant had knowingly provided false information in financial statements. And it's suggested that what the defence says in paragraph 84 is that that part of the report is not about asset value. It's about MML, and therefore it's legitimate to put forward that evidence. Well, we're surprised by that contention, namely that it's nothing to do with inflated asset values when it talks about the false inflation of financial statements. But in any event, once again, we suggest that in circumstances where the whole of the content of both parties' case in relation to MML has been deleted, and in light of the point taken in paragraph 67.2 of the defence, we suggest that that is a matter that should be pleaded if it is said to be relevant to that issue. Your Honour, I don't think I want to say anything else on the substance. What I will say by way of conclusion is that if Your Honour is against us and this evidence is to stay in, then we submit we must have the opportunity to respond to that evidence. Firstly, it's not fair to characterise us as guilty of any significant delay in relation to this. You'll have seen that the evidence was served in this case on the 30th of November. Within 2 weeks, we'd set out our letter of the 14th of December, explaining in some detail what our objections were. But no delay there. We explicitly reserved our position in relation to the service of supplementary evidence on this point. The reference, Your Honour, is at it's tab 38 of bundle 2. So that's our letter of the 14th of December. We set out all of our complaints in relation to the evidence. And at the end, last paragraph, we say, while reserving the right to reply to sections of Protiviti's witness evidence in relation to the contract with MML, should it remain before the court, the claims do not at present intend to serve any evidence in reply. Your Honour, in circumstances where, as I hope I've made clear, our real concerns about this evidence is firstly, obviously, a concern that it's not relevant to any issues, but if it's going to stay in, it will require significant further evidence from ourselves and the attendant time and costs involved. It was a perfectly sensible thing to do in my submission, that we didn't embark on preparing evidence in response to evidence which we did not consider should properly be admitted. There remains sufficient time in the timetable to serve further evidence. It would be wholly unfair in my submission. In the event that we were going to stop the application itself, we were not permitted to put in additional evidence to deal with it.
Yes, thank you. I confess, I'm sorry, have you finished?
I have finished, yes, thank you.
One point I would just raise in passing, it was a matter of some surprise, no more than that, but in paragraph 115 of the amended particulars of claim, the MML has been transposed with the company for some reason. How does that come about?
I'm afraid I can't explain that. That reading predates by some significant time.
Right, well, thank you very much. I'm not persuaded that it's appropriate to make an order excluding the evidence that is identified in bundle 2 of at divider 35, which is challenged by the claimants. I confess that there is a risk that some of this material will be of very marginal materiality. And so what I propose to do is to keep this matter under advisement, and we shall see whether the topic attracts the time and money which it should not receive, and whether the argument trespasses outside of the boundaries of the pleaded case. So I'm going to say no more than I repeat what I think I said at the opening of this hearing, that as a matter of first impression, this was a matter which should be dealt with at the trial by the trial judge, and matters will be left in that way. Now, let me come back to the trial itself. I'd already, I think, mentioned the point that it seems desirable to set up a timetable for the experts to meet, even at the cost of postponing supplementary reports in the light of what remains unagreed, rather than to have a full-blown supplemental report across the board. I will need some help from counsel on that proposal. Having looked again at the case memorandum filed by the parties, I note that the claimants put the figure of the minimum of 3 weeks, while the defendants thought the appropriate period was sometime between 8 and 12 days. Cases of this length very seldom last to the length that they are estimated to take. But this is a case in which it's going to be necessary to keep a very sharp eye on what the appropriate period is for cross-examination of witnesses and experts. So the trial timetable must be a detailed trial timetable, which must be produced in good time for consideration at the pre-trial review. It's notable that the size of the statements vary substantially. Some are quite short, some are exorbitantly long. Suffering as usual from the defect of quoting substantially from the documentation. I shall need a clear identification of how long individual witnesses really need to be cross-examined. Much depends on how much of this material is really controversial, or whether it's simply repeating what's in the document. Which leads to the next point, I think. We have a PTR presently fixed for the 3rd of April. I think that's the date.
Yes, I think so.
Yeah, which is what, a month before the trial, roughly. The other relevant dates. Sorry, I've just lost the case management order. Here we go. Okay. Now, can I just check the reply statement, witness statements, have they been served?
Witness statements have been served, supplementary statements have been served by the defendant. Obviously,
No, I'm not talking about
one thing we wanted to.
Reply statements were due in November from, hang on, I'm not sure I followed this.
Yes, I think the original case management order was subject to an agreed amendment. So in the event, first round witness statements were served on, I think, the 30th of November. I think second round supplementaries were served mid-December. 21st of December, I'm told.
Say that again, second round supplementary statement?
Supplementary factual witness statements were served on the 21st of December.
They were?
Yes.
Right. Okay, so paragraph 17 of the case management order has been complied with. Well, somebody sitting behind you must know what the answer is.
Yes, it has been.
Yes.
Right. So we can forget about paragraph 17. Thank you very much. Now, 19, sorry, let's start with 20. So the reference to amendments made by consent, what's that a reference to?
Your Honour, can I check that we're on the same order? I think...
I'm no idea. I'm looking at divider 13.
Yes, it should be divided 14.
Ah, that could explain why I'm going wrong. Thank you. Yeah. Sorry about that. Right, I'm now with you. So, the claimant should have filed. Sorry, the expert's report should have been filed on the 14th of December. Did that happen?
No, that's not yet happened. The IPO expert, there is a current agreement by which our IPO expert will serve his report on the 18th of January, so that's later this week.
Right. So that's, poor Mr. Hunt is the man who's unwell, is it? Right? Yeah. And what about Mr.
Yes. Although that's the current order, the best way to work in relation to other corrections may be to look at the draft order that's attached to the agenda for today. So that's tab 21. Because a number of updates have been made, largely by agreement between the parties. So if I can ask you to look at page 286B.
Yeah, I have that now.
You'll see the operative.
So the service, the operative one is paragraph 3, is it?
Well, can I, perhaps if we go through from paragraph 1.
You take me through. Yeah.
Yeah, paragraph 1 deals with the expert reports which
Right.
are going to be served simultaneously.
Yes.
Now, firstly, and the parties are currently agreed that the date for exchange of these expert reports should be postponed from the 25th of January, as they are currently, to the 8th of February, which is why the 8th of February appears in paragraph 1. So, subject to Your Honour's approval, that is agreed. In A, Your Honour sees that there is a blank as to who will be providing our forensic accountancy evidence. That is the ill health point, Your Honour. As you know, our current expert is very unwell indeed. We've provided details by way of letter to the court and in our skeleton. And we ask Your Honour's permission to adduce evidence from Mr. David Eastwood of FTI. He is the colleague of Mr. Hunt.
No, I understand.
So David Eastwood.
What about paragraph 3? Is that done?
Before we get to paragraph 3, if I can detain you on paragraph 2,
Yes.
the 1st of March is the current date for supplemental expert reports.
Yeah.
Now, clearly, Your Honour has said something about meetings between experts. We've endeavoured in the short break we had to have a dialogue. We've not managed as yet to agree any detail in relation to that, although I think it's fair to summarise both parties' position as being agreeable to the idea of experts meetings. But
Yes, what I contemplate is that there should be a meeting as an appropriate date, maybe early March, I don't know, and that there be a joint memorandum as to what they agree or don't agree about, and if they either want to serve a supplementary report, they can within, say, 2 weeks of that.
Well,
Does that make sense?
That does make sense. I think, in principle, parties are likely to be agreeable to that.
Yeah, Your Honour, that does make sense. I should say I haven't been able to take instructions because my instructing solicitors are in court with you, and I wasn't able to raise them in the short...
Instructions on what topic?
On the question of meetings. I expect that we will take the same stance as Mr. Head has just outlined, that we would see the good sense of what Your Honour has proposed.
And so I'm still not understanding why you need instructions. Instructions on what topic?
On the question of expert meetings, Your Honour.
Well, do you think they might disagree and not have
I
it?
don't contemplate that at the moment, Your Honour, but all I'm
Well, they
raising
won't
is
get
that I
away
haven't
with
been
it
able
with
to-
me. Well, you can come back to me if you want to make a complaint, but I'm going to order that there will be a meeting between these experts, and following that meeting, the joint experts will produce a joint report, and if they so advise, they can produce a supplementary report. Okay?
I'm not seeking to oppose that, Your Honour. I just wanted to point out for the record that I haven't been able to take instructions.
Now, what about paragraphs 3 and 4?
Before we move on from paragraph 2, Your Honour, can we just say, so far as the order, will you leave it to the parties just to agree sensible dates in early March for the meeting of experts, and then perhaps a date around the middle of March for supplementary reports?
Yes, I'm happy with that.
Very good. Yes, now, 3 and 4, Your Honour, go together because it was ordered back at the first CMC in March last year that the evidence in relation to the IPO valuation and methodology should be sequential, not by exchange. Now, as things stand, we're due to serve our report, as you can see in paragraph 3, on the 18th of January. We're there or thereabouts. It is, as I indicated in my skeleton, there is a possibility that we may need another day or two, but I do mean a very short additional period to finalise that report. I'm not sure I need to trouble you with that now. We hope we can simply deal with that between the parties. In short, I don't think that paragraphs 3 or 4 need amendment at this stage, that they can stay as they are.
Now again, I would have thought a meeting was better than supplemental reports.
I suspect that the parties, given the court's indications, I'm sure the parties will endeavour to agree something along those lines. Again, perhaps Your Honour will trust the parties to engage with the precise dates on that between the service of the reports and any supplementary evidence.
Right, I'm happy with that.
It then means that paragraph 8 can come out, I think.
Well, 8 we can jump over 9. Can I just get a feel for dates here? What is described as the normal range, 4 to 8 weeks. that is in fact what, about 5 weeks before the trial. 8
Yes,
weeks would be mid-March, right?
8 weeks would be, yes, mid to early to mid-March.
But by mid-March we might not have got through the expert evidence. I don't know.
Well, certainly we would. As you'll have seen, Your Honour, I think all parties are agreeable to the idea that trial bundles should be prepared at a pretty early stage. It's going to help all the advocates involved. So I think we sing with one voice on that. Now, it's not going to, and I think we're aiming for a date in very early March for the preparation of trial bundles. Now, if it means that there are a few blank tabs for insertion of later reports, so be it. But and realistically, it does seem that some expert documents are not going to be finalised until mid-March or thereabouts.
I mean, I think I only raised the point. I think it's probably not possible. I am back here in Dubai in the middle of March, but that's probably too early to bring forward the progress monitoring hearing or pre-trial review. So we'll have to do it by video link, I suppose. Okay.
Well,
Now,
I think as things stand, Your Honour, I think we're scheduled to be there in person on the 3rd of April.
yes, well, maybe I'm not that keen to come out, but I possibly can. Okay, well, let's leave that. I'm not sure. Let me just hang on a minute. It's Easter Tuesday, isn't it?
Yes.
Yeah. Okay. Well, let's leave that there for the moment. The reading in this case for the judge is enormous, isn't it? I mean, I'm just doing a bit of a tot-up. We got a 150-page report. We got about 200 or 300 pages of witness statements, and then there are various experts' reports. I think that it's important that the court be provided with we've got it, I suppose, a copy of the report, a copy of the witness statements and supplementaries, and a copy of such experts' reports as are in existence, and by the time of the pre-trial review. Right.
But certainly we can arrange for that to happen, Your Honour. So far as paragraph 11 is concerned,
Yes.
as you've heard, we're going to endeavour to drag that date forward, certainly so far as the parties are concerned. It's obviously a matter for the court as to when it would be helpful to receive the trial bundles as a whole, rather than simply...
Well, as soon as the parties receive them, yeah.
Very well.
As soon as the parties receive them.
Yes, well, we're I'm sure all happy that should take place.
Okay. Now, at the moment, as I was saying, you're calling one witness who will give evidence from Geneva. The defendants have, I think, 7 witness statements or 7 witnesses. Have I got that right?
Yes.
Are you wanting to cross-examine them all?
At present, yes. Your Honour.
Right. Well then, as I say, you're going to have to identify precisely how long you want with each of them in time for the pre-trial review. Thank you. Yes. Now, while we're together, any more?
Yes, can I just raise a few more points? Is Your Honour content with the timing of skeleton arguments, given that there will be significant reading?
I'm happy with you want to increase their size. Yes, I'm happy with that.
Yes.
And what's the timing? A week, is it?
Well, 7 days for us and 5 days for the defendant is suggested.
Okay, no, that's all right.
Grateful. Before we move on to one or two further points not yet covered, I don't think you have yet ruled on the question as to whether my client, the second claimant, is entitled to serve evidence in relation to the MML matter.
Yes, if so advised, you can serve it. I think what time are you putting on that?
Can I suggest?
Are we talking documents or statements?
Witness statements. I suspect a supplemental witness statement.
And a supplemental witness statement within what, 2 weeks?
I'd ask for 21 days.
Ask for what? How long?
I ask for 21 days, Your Honour.
21 days. Yes, Mr. Mohammad.
Well, I think 14 days is adequate, Your Honour. The passages in my learned friend's current witness statement dealing with the substantive criticisms are very short. They run to about 4 or 5 pages altogether. I don't anticipate that there's going to be a long statement in response, and the sooner we can see it, the better.
Yeah. No, you're going to have 21 days.
Grateful. Then we had I think that covers the draft order, Your Honour. We have some sort of ancillary questions, if I can put it that way.
Yeah.
The estimate is 3 to 4 weeks, as you know, and we've all heard Lordship's encouragement to deal carefully with the trial timetabling in advance of the PTR, so we'll do that. Can we confirm, does Your Honour intend to sit 4 or 5 days at the trial per week?
5? Where do you get the idea of 4 from?
No, I think we had all...
Tempting as it is, I can't deny.
No, well, that's fine.
No, it's a 5-day week.
Proceed on that basis.
All right. Now we will sit 5 days, and I'm subject to availability, and we'll probably sit from 10 till 5, with breaks in the morning and the afternoon.
As Your Honour will have seen from the skeletons, we are conscious that Ramadan starts midway through the trial on the 14th of May, given the start date of the 6th of May.
Well, it gives you all the more reason to push on.
It does. I mean, I think it's right. I'm told by Mr. Brockbank that 2 of his witnesses will be fasting. We think probably the timing is fine as far as they're concerned, because they will give evidence before Ramadan starts. Similarly, with my client, who I understand will be fasting, he will give evidence before Ramadan, so that's no difficulty. The potential difficulties are those of experts, particularly one suspects Saudi law experts, who will be fasting and who in the ordinary course will be giving evidence during the Ramadan period. And similarly, we're conscious that court staff may be similarly affected. So really, we just raise it in order that we should be aware if there are points to make, or whether I don't know if the court would ordinarily sit different hours or anything of that sort in order to accommodate those individuals.
Good question. I can't remember. I'm not sure I've sat in Ramadan for quite some time, but I will obviously make inquiries.
Very grateful, Your Honour. Your Honour has seen there's agreement about transcribers for the trial. Oh, yes, Your Honour, you'll have seen that there is now an agreed list of issues.
Yes, and that was excellent. Well done. Thank you.
I take it that Your Honour approves, and we can move on. I think
Yes.
with that then dealt with, I think that covers everything that was on the agenda, unless anyone else.
Your Honour, the only item potentially outstanding, is the costs of the application that Your Honour dismissed. Now, I appreciate Your Honour said that it's a matter you will want to keep under advisement, but in terms of the costs of turning up today and arguing about it, we said that it was the wrong time to deal with it. Your Honour has effectively agreed with that, and on that basis, I would ask that Your Honour make a costs award in our favour.
Now I'm going to reserve costs on that. Yes, unless you want to do better than that.
Well, Your Honour, I think what I would say is that, yes, a way of backup, it should be no worse than reserving costs, but we suggest this is a case management matter, something that was quite properly raised at the case management conference, and Your Honour dealt with it, expressed a view as to that it should be kept under advisement. That is a classic bit of case management, so cost in the case should be the appropriate order.
No, I'm reserving costs on that. Yeah. Okay. That it?
Your Honour, I think that concludes all business for today. We're very grateful for your patience.
Thank you very much indeed. And you no doubt will be in touch with the court with your proposed timetable or revision of the case management order, and in due course we'll prepare for the PTR. Thank you very much indeed.
Thank you.
All rise.
Question.